Namaskar. I'm CA Ramesh Prabhu, Chairman, Maharashtra Societies Welfare Association. Today I am bringing you in the latest news of real estate cooperating societies or auditors. Today I am coming out with a very good landmark decision of the Honorable Supreme Court. A matter was decided by the Honorable Supreme Court on 17th December 2024. The matter is nothing but a very simple matter of illegal construction and on which the purchaser was enjoying the property for a longer time. What happened was a case filed by Rajendra Kumar Barajatia and another against UP Awas Evam Vikas Parishad and others in the year 2024 before the Honorable Supreme Court in the civil appeal number 14604 and 14605 of 2024. Now in a particular case, what happened was the petitioner had filed a writ petition or special leave petition against the judgment of the Honorable High Court, where Honorable High Court has directed that the authorities should demolish the illegal construction carried out in the plot. A purchaser whom the plot was allotted by UP government for a residential purpose, he constructed there on a commercial premises. Having constructed the commercial premises, thereafter the premises was sold to subsequent buyer who is now before the Honorable Supreme Court. In the year 2011, he purchased it. But in this case, UP Awas Evam Vikas Parishad had directed for the demolition of the illegal structure in the year 2011. In spite of this order of the demolition, the party continued with the litigation and subsequently Mr. Rajendra Kumar Barajatia purchased the illegal structure. Thereafter, the matter went to the Honorable High Court, which has of course confirmed the demolition order, and the matter when it came to the Honorable Supreme Court also has upheld the decision of the Honorable High Court. Now, what are the direction especially for this case, and then what are the general direction given by the Honorable Supreme Court is very important for us to know. First and foremost, the Honorable Supreme Court said legality of the unauthorized construction cannot be done. If there is a structure which is illegal, it has to be demolished. So there is no compromise. And just because some structure is illegally standing for so many years does not mean that can be legalized. Second and very important thing is accountability of the authorities. It is the duty of the authorities to see that if there are illegal construction, that has to be demolished. There is no question of compromising or allowing such structure to remain there. Third thing, Honorable Supreme Court said doctrine of caveat of emptor, which means the buyer should be aware. When the buyer is aware that there are illegal construction which is buying, it is his duty to see all this title, and knowingly if he has bought the property without verifying the title, he cannot take the excuse of that. And the last is, it is in the public interest over the private gains. That means if there is some private gain, one has to look at what is the public loss, what is in the public interest. If this type of illegal construction is going to be allowed for the purpose of somebody's private benefit, then there cannot be law and order. There cannot be the system. The urban development can become into hell. And therefore, the Honorable Supreme Court said there is no question of allowing such structure to be continued. It has to be demolished. Now, so far so good. It was related to particular judgment. Let me now tell you, the Honorable Supreme Court has given the general guidelines of 12 points which need to be adhered by each of the promoters, authorities and various concerned stakeholders in the process of either redevelopment or the development that is going to happen henceforward, that is from 17th December 2024. What are these 12 directions? Let us understand. I am here to tell you the 12 important directions which Honorable Supreme Court has laid down in the case of illegal construction, in the case of preventing the illegal construction, in the case of not occupying or not to allow the occupying a building or the flat or premises or any of the buildings without having complete occupation certificate or completion certificate. Let us move to one by one 12 direction issued by the Honorable Supreme Court on 17th December 2024 in the case of Rajendra Kumar versus UP Evam Awas Parishad. First and foremost, henceforward, every developer and the promoter and the builder is required to give an undertaking to the competent authority that he will not allow anybody to occupy the completed building without having completion or occupation certificate. That means the builder has to give an undertaking to the competent authority before gets the plan approved, saying that he will not allow anybody to occupy without the OC and the completion certificate. The second and most important thing, every developer, it is the duty of the developer to put the approved plan at the site, and not only at the approved plan at the site, it is also the duty of the authority, competent authority, to inspect whether the such plans have been displayed at the site, so that the person comes to know what is the level at which the building has been approved by the competent authority, and regular inspection has to be kept. Not only that, after doing the inspection, the record for carrying out the inspection should be kept in the office records of the competent authority. The third important direction is completion and occupation certificate has to be given only after verifying that the building is completed as per the required plan. If there is any deviation, unless until that deviation is rectified, no occupation certificate or completion certificate should be given to the concerned developer. Fourth, service connections and conditional on compliance. All the service connections such as water connection, electric connection, sewerage connection, which is basic requirement to habitate or live in a building, should be provided only after producing the completion certificate or the occupation certificate as required under the local law. Which means now no more water connection, electric connection or sewerage connection will be given to the building or the completed project unless until the building has occupation certificate. The fifth direction is that the action should be initiated by the competent authority if there is any deviation of the approved plan. If there is any deviation which is illegal construction which is carried out by any builder, promoter, owner, occupier, immediate action should be taken by the authority, and if the authorities fail to take the action, naturally action will be initiated even against the authorities. The Honorable Supreme Court has said in the sixth direction that no business licenses on unauthorized construction. That is, henceforward, no license of whatsoever will be allowed on the premises, either residential or commercial, to carry out any activities in that premises by any government authority. Seventh direction is that all the building plan, approved plan, layout plan, everything has to be conformity with the zonal plans. The environment impact has to be taken into. Without considering all this aspect, the plan cannot be approved. And if there is any modification has to be done, it has to be as per the zonal plan. That means development control and promotion regulation, or what we know as normally development plan. The eighth direction is there has to be interdepartmental cooperation, which means in case the competent authority would like to demolish the illegal structure or want cooperation from another department, whether it is a RERA, whether it is any other department like MMRDA, MADA or landowners, or to that extent police department. The inter-department need to extend full cooperation and share the required document so that the illegality is stopped and further actions are not taken on that. So this is also very important direction given by the Honorable Supreme Court. The ninth very important direction is that any application, revision or given or appeal in the case of the completion certificate, occupation certificate should be disposed of by the competent authority within 90 days of such appeal, application or rectification, revision application which has been filed. And if there is any deviation, it has to be rejected or decided within 90 days. There cannot be keeping any appeals related to completion certificate, occupation certificate for a period exceeding 90 days by any authority, including the honorable courts. 10th direction is that the state governments, union territory governments have been issued a direction that the required circular and notification should be issued to the concerned department that they adhere to the various guidelines given in this, and if there is any deviation, naturally the disciplinary action has to be taken against hearing officer. That means now the officer concerned has to follow this direction. If he does not follow, there can be contempt of court also. There can be disciplinary action against such officers. The 11th direction is very important. The flat purchaser or the apartment purchaser will not be able to take the loan. The direction has been issued to the housing finance companies, financial institutions, that no loan should be granted to any building which does not have occupation certificate and completion certificate, which means it's going to affect in a great way whether now going forward whether under construction property will get a loan or not is now a question mark. However, without completion certificate, final disbursement will not take place. The 12th direction is most important, and this is the entire theme of the direction. It has been clearly laid down in this Supreme Court judgment that any officer, any authority, anybody does not comply with the 11th direction that has been given will be considered as a contempt of the Honorable Supreme Court judgment, which means the officer now will have to be on the toe and he has to follow each of the directions. What is the end result of this? Henceforward, whether it is RERA, whether it is a common authority, whether it is a high court, whether it is a Supreme Court or any of the city civil court or the consumer court will not be able to direct any of the flat purchaser to occupy the premises without OC. It is also possible that the BMC and other authorities, the electric department will not be able to give an electric connection, water connection, sewerage connection, pipeline connection, which is most important, like gas connection, unless until the building has got the completion certificate. So this is one of the most landmarking judgment. Why? Because in the year 2017, we have seen RERA came to regulate the illegal structure. Now, after about another 7 years, we have seen that RERA also could not make much impact to stop the illegal structure, illegal construction. So even today, some of the developers are handing over the possession of the premises without occupation certificate. With this direction, the concerned officer will be in trouble if he allows him to occupy and if any connections, any water connection, electric connections are given. So therefore, now it will be strict adherence of the approved plan, strict adherence to the development plan is the need of the hour, and this is what this Honorable Supreme Court judgment says. Thank you very much. Please listen to my videos again and again, share it, like it, and circulate to your members to exercise your legitimate right. Thank you very much.